I still can.
If he can, if he's looking up.
All rise. At 6:34 on this, the third day of April, presiding over case number 2022-02, Chief Justice Mark Brooks, Justice Kelvin Jacobs, Justice Tana Jacobs, and Justice Eric Freeman.
Good evening. It's been a while since we've done this, so I hope y'all are not as rusty as I am. Welcome everyone being here. This is one of the most important things that we do as a tribe, as tribal government, is we conduct the Supreme Court hearing, and it's a great right that's afforded to our Lumbee people. Have a question or a controversy or a case is what our Constitution calls it, that needs to be decided. This is why we go through a nomination process. This is why we go through a confirmation process by our tribal council to appoint us. Case, hear it fairly, hear it justly, and make a just. I want to go through some housekeeping matters first. Court's going to ask the parties, start with the petitioners. Let the petitioners, respondents introduce themselves. If you're represented by counsel, please introduce yourself. And then we'll go through some logistical housekeeping matters. We'll address potential conflicts. I might start. I probably should have did this first. I'm Mark Brooks. I'm serving as Chief Justice for this Supreme Court. And I am from the Pembroke community. And I'll start with my left if each justice would just state their name and what community they're from.
Good evening. My name is Eric Freeman, and I'm from the Prospect community.
Good evening, Tona Jacobs, and I am from Hoke County.
Good evening, everyone. It's Kelvin Jacobs, and I'm from the Parkton community on the Cumberland County side.
I'll ask the petitioners. This is petitioners, right? Yeah. Petitioners, introduce yourselves to the court.
Sheila Beck,
Community are you from?
Saddle Tree.
Okay.
Louise Mitchell from the District 2 Community, Smyrna, Fairmont, the area.
My name's Sam Kearns. I'm from Lumberton.
My name's Perlane Rebels, and I'm from Lumberton, St. Paul's.
Gary Deese, Fairmont area.
Thank you. Welcome. Respondents, introduce yourselves.
Daniel Locklear, counsel for the council, and I'm from Wakulla.
Erin Hunt, speaker. I represent District 2, which I'm of the Smyrna community, but I represent Back Swamp, Smyrna, and Fairmont.
Ricky Burnett from District 13, Cumberland County.
At this time, I think it's one of the more important things that we do before we begin a hearing. Invite both parties to freely indicate if they believe that there is potential conflict with any of the justices that you reason prevent any one of us from hearing this case and making a decision fairly as a reasonable person would. I'll start with the petitioners.
I'm wondering if there is a conflict of interest with one of the justices for this hearing, who is a cousin to one of the respondents. Should I name?
Yes.
Mr. Kelvin Jacobs.
Okay.
Is first cousins to Miss Sharon Hunt.
Does the petitioners have any other conflicts other than that one that they would like to?
Not my knowledge.
Respondents, does the respondents have any actual parent conflicts that they would like to make the court aware of?
I'm Judge.
Having heard you, Petitioner Mitchell, I would turn this over to Justice Jacobs to let him respond.
Thank you. I do appreciate you bringing that to everyone's attention. Ms. Sharon Hunt is my first cousin. The Chief Justice, I have no qualms about hearing this case, and I do believe I can be fair, impartial, and unbiased.
Let me just say that obviously this court wants to act with utmost integrity and impropriety. One of the challenges that you face when you are a tribal government made up of a tribe of kinfolk, one of the situations that often will occur is that there will be relatives on court. I don't see any of my actual relatives or extended relatives, but I have been on this court before where that has happened. And I would just state in fairness to both you, Ms. Mitchell, as well as Jacobs, I do believe that he can act fairly and impartially. I don't know personally, I don't know if any of the other justices can speak as to personal relationship between Speaker Hunt and Justice Kelvin Jacobs, but I would say that them being first cousins simply would not preclude Justice Jacobs. I would open the floor up to the other justices if they would like to comment or if they agree or disagree with Justice Jacobs' position. Hearing none, is there any other remarks by the petitioners concerning potential conflict? I would invite the justices. Do any of the justices have any actual or apparent conflicts that they would like to address with the court? Hearing none, we'll begin this hearing on the substance of it. This is every hearing that comes in front of this court is important. I don't want to suggest that this hearing is more important than any other hearing, but this one, at least to our first impression as justices is we've had a chance to meet numerous times. We've spent several hours deliberating amongst ourselves collectively about this case. I know that we've spent considerable time as individuals going over the pleadings, looking at the petition, looking at the answer. As a legal professional, as an attorney, I have to say that both documents were extremely well pled. I think the petitioners pled a very clear and precise pleading. I believe that the counsel was served well with the response. It made some compelling arguments. I think that this court has taken those arguments very seriously. Purpose of this hearing then is to give each party a chance to persuade this court what the court ought to do. And we have met amongst ourselves, and we've decided that we believe that it may be helpful if the court, before the parties present any type of arguments, and our intention is to allow the petitioners to make an opening statement, let the respondents make an opening statement, and then hand the court over to the petitioners and let you present your first evidence and present your case. Before we do that, though, we believe that it may be helpful for the court to just state what we believe the issue or issues are, and we want each side to let us know if they agree that we see the issues clearly. Petitioners, looking at your pleading, it appears that the ultimate issue of concern is that you are asking this court to find that the tribal council has acted unlawfully, that may be a strong word, unconstitutionally, in violating their own ordinance as it relates to the appointment of persons to an outside board or committee. Is that accurate thus far? And seated council members. And you are asking this court to find specifically that the council has violated their own ordinance because they have appointed a seated council member to a non-council board position when their ordinance states that they are to the extent possible appoint a non-council member. Is that to the extent possible? You agree that that's the issue that's before us? Does the respondent believe that that is the issue before this court?
Purview of the court.
I don't want to interrupt you, Councilor Locklear. Are there mics? Mine seems to be a bit louder.
Do we get, okay. I think the first issue would be whether or not this is an issue that's giving rise to the court's jurisdiction, or whether or not it's within the purview of the council to determine how these appointments are made. I think that's the first issue. And then secondly, if the court then determines that it's an issue outside of the council's own, then that would be the issue as to whether or not there was a violation of the ordinance. There's two parts. The first part would be whether or not this is something before the court, whether this is a matter that inherent authority rests with the council to decide how it's done. And then if the court decides that it's not within their authority, then the examination of whether or not a violation occurred.
And I believe, Councilor Locklear, that to some degree that's a reciting of the respondent's response to this. I don't want to jump ahead too much. I do think that those are issues that are under consideration. I want to narrow this singular issue, that the one question, and we'll take all those other concerns into consideration. But would you agree that the single issue where the court may have to incorporate or consider all those issues that you just raised is whether or not the council has acted improperly by making this particular appointment of a seated council member to a non-council position instead of a non-council member to the extent possible? Would you agree that that's the issue before this court? That being the issue, this court believes that it's important, necessary. It's necessary that this court is persuaded, and this will probably touch on some of Mr. Lockalier's points that he just made, and this is what this court needs to be convinced of. This court needs to be convinced that, one, this court has the authority to determine not just the constitutionality of an ordinance, but whether or not this court has the authority to hear the merits of an ordinance in its performance. So in other words, I don't believe that we're here tonight to determine whether or not this ordinance is constitutional. I don't think we're here tonight because the petitioners are saying that when the tribal council enacted this ordinance, and what year is it, Madam?
2005.
2005. I don't believe that the petitioners are arguing that when the council passed this ordinance, that it was unconstitutional. Is that a fair statement?
Yes.
I believe that the petitioners are asking us that they have failed to adhere to that ordinance.
Yes.
Okay. So this court needs to be convinced first that that is something that this court can consider. Second thing that this court needs to be convinced of is that if this court can consider that question, that this is not a separation of powers issue. That if the court were to make this decision, that the council has not acted to the extent possible to appoint a non-council member to a non-council position, that we would not be acting in a legislative way, and in doing so, violating our Constitution's separation of powers. Does that make sense? And I've said that because I want the parties to have the benefit that when you make your case, make your opening statement, that you know specifically what this court is looking for. Does any of the other justices have any remarks before we turn this hearing over to the petitioners?
Your Honor.
Or who spoke?
That was me.
Okay, sorry, Mr. Locklear.
Will there be a time where we be allowed for preliminary motions prior to the hearing?
We will hear it, and we'll take it under advisement. That's something that the respondents would like to do at this time?
Yes.
Okay, feel free.
Need to stand in this court?
I would say that you can come to the podium, Mr. Locklear.
An examination of the petition that was filed, and in normal standards it involves a court case, and in this being one. I think first of all, the petitioners have failed to establish that they have standing to bring the matter. At no point in the petition was it ever argued or asserted that they had been harmed or damaged in any way. and that would give rise to standing. You simply can't have a group of people displeased with government and that be standing alone. That'd be no different from me suing the government for spending money on bombs when I think they should have been buying buildings. So standing is the first concern that we would have, is that the petitioners are not harmed, have not been injured, and therefore doesn't have standing. Secondly is a mootness. I think that at this time, currently the way it sits, there is no seated council member that's appointed a board or commission. So what would have been a controversy is no longer such and would render their point moot and no longer justiciable. On those two bases of non-justiciability, we were asking to dismiss the petition.
Would the petitioners like to respond to that motion? You can come to the podium if you'd like to. You can if you'd like.
Your Honor, we do believe that we have standing. This petition was filed whenever the person that is appointed to the North Carolina Indian Housing Authority and the North Carolina Indian Commission was in position in their seated capacity. They were there until there was a new council that was elected and they were sworn in. So we do have standing that these appointments have been made when a seated council member has been sitting on council.
Can I just, Paul, interrupt you just for a minute,
Yes.
Ms. Mitchell? I think Mr. Locklear, I think the argument that he's making for lack of standing, he's arguing that the petitioners have failed to allege how they have been harmed. And I'm not saying to you that the court needs to be persuaded of that. I'm just asking if you would like to have an opportunity to respond to that particular allegation that he made.
Well, not all these petitioners, that are here, have had the incident that I had, but I'm saying that we have standing as tribal members. We see that the law has been violated, and if one law is violated and it's been corrected of a removal, then all other laws that are in place that are in violation should be of removal too.
As to his second point of this being a moot matter,
I do not believe it's a moot matter because we still have one person that is a seated council member that is serving on a affiliated position, and I would argue again that when these appointments were made, they were seated council members at the time.
do any of the other justices have any questions for either Counselor Locklear or Ms. Mitchell? For the sake of efficiency, it may be an inconvenience for every time someone needs to speak to come to the podium. We recognize that. So if you would prefer to, unless we're making opening statements or closing statements, I would ask at those times to come to the podium. I have a question for Mr. Locklear. Can you point the court at some place that says in our tribal government law that a person needs to show harm in order to have standing in a case before the Supreme Court? Yes, take your time. Mr. Locklear, we will take that question under advisement, and for the sake of expediency, we will return to that issue if you can provide us.
Or the outside of federal common law and under federal common law. But that's referenced in the Constitution. It's just going to take me a minute to track it down specifically. But outside of there being some tribal rule or established precedent, then federal common law will stand in its place.
Does do any of the other justices want to respond to either the petitioner or respondent at this time?
Justice, if I may, our own judicial code states that the basis of a complaint, any issue brought to the court must involve a case or controversy arising out of an alleged violation pursuant to the Lumbee Tribal Constitution or duly adopted tribal ordinance. Petitioner feels violated. So again, I guess my point is I do not see in our judicial code where the petitioner must demonstrate that outside of being a tribal member has been necessarily harmed by the ordinance in question. How and why they feel the violation is in conflict with the
Again, I do think that is something, Mr. Locklear, that this court will take into advisement when we break to deliberate, possibly at several times during this hearing. My initial impression is that the Constitution, when it says that this court shall have judicial authority over all cases and controversies arising out of either the Constitution or enacted ordinances, I believe that gives a broad view of standing. I tend to agree initially, at least, with Ms. Mitchell's indication that as a tribal member, that gives them standing. At this time, we will take both of those. Does Mr. Locklear want to respond to Ms. Mitchell's indication that there is another, without getting into any facts, we haven't heard any, she's made the indication that there's another seated council member on a non-council board?
We're unaware of any council member that's seated on any board.
We will return to these issues if the court feels that it's necessary to do so, but this time we will turn the hearing over to the petitioners and let them present their case. Or opening statement, I'm sorry.
Honorable Justices of the Supreme Court of the Lumbee Tribe of North Carolina, we the petitioners, tribal members, appreciate your time and courtesy in hearing this matter. No Lumbee lawmaker is above the law. If you are a Lumbee tribal member or even a Lumbee tribal council representative, you are bound by what is written in black and white in the form of our Constitution and ordinances. This is a petition about existing violations of tribal laws precipitated by actions of the council's procedural duties and appointments of seated council members to tribal government affiliated positions not constitutionally mandated to organizations, boards, and entities. This is about abiding by the Lumbee laws that are written by Lumbee lawmakers. This is not about questioning the legislative authority of our lawmakers. This is not about the qualification of individuals. This hearing is not a personal vindication upon former, present, or new council members. This is about 35,000 tribal members that are potentially willing, able, and qualified to serve on committees, appointments, and governmental affiliated positions that are not serving on tribal council. This hearing is about failure to follow and adhere to Lumbee tribal laws, causing violations in the official duties of the legislative branch because the lawmakers did not, to the extent possible, consider appointing non-council members. The petitioners, in my summary, is the petitioners' tribal members' explicit belief is that all tribal laws shall be followed and adhered to by all the branches of the government and membership of the Lumbee Tribe of North Carolina to prevent conflict of interest and controversies arising in the execution of laws. The express sovereignty of power held by the Lumbee Tribe's Constitution and laws of self-determination is an anticipated respect of our laws by states, state courts, organizations, boards, and entities for the Lumbee people's way of life and community.
Thank you, Ms. Mitchell.
Justice, this is a matter where seemingly a few have been disgruntled with the council's decision. These council members, there's 21 of them comprised from several different districts within the Lumbee territory. They have the most direct contact with the most Lumbee people. They would have the first-hand working knowledge of who those members of the citizenry of the Lumbee tribe to be able to make these recommendations to best suit the interest of the Lumbee people on these boards and whatever appointments that may come. It is our position that there is no absolute in this rule that exists that would it would keep them from appointing each other on these boards and commissions. Some of these require specialized knowledge or interest, and those members of the council sometimes will be the best person for that position. But it's no limit to them being able to appoint from the commission. They only have to give it a high priority that they select outside of that. So these are the people who have the best interest of the Lumbee people at heart. They have the most relationships in the communities to be able to determine who the best people would be to select for these committees. They did not break the ordinance in their selection. There's an argument that's been made by the petitioners that they didn't like the way they done the selection. But they're certainly not in violation of the ordinance when they made the selections they did. That's the question to be determined. Was there a violation of the ordinance? The ordinance does not say that absolutely the council members cannot be seated on boards and commissions. That's the question. Because it is an absolute, they are allowed to do so, therefore not a violation. Now, if we want to get into whether they're given the highest priority or whether we want to get into those specific definitions, we can. But my argument's still going to be that these are the people who are given these positions to make the best decisions for the Lumbee tribe in placement on these boards and commissions. That is their responsibility. That is their inherent authority. They have the power to do so, the responsibility to do so, and they're responsible for making the best decision. And we think that they did, and that's our position. It's not in violation of any ordinance.
Thank you, Mr. Locklear. At this time, if the petitioner is ready to present their first witness.
We have no witness to call except for the petitioners that are here. If you're referring to, do we have someone to testify?
Yes.
On our behalf? No, we do not have a witness.
How does the petitioners wish to proceed as far as presenting their case?
We would like to proceed with the petition of why we feel that the tribal council in present past has appointed tribal members, seated council members to seats and they're not supposed to by law.
How do you wish to do that apart from calling a witness?
I would just like to go through what I have as a short term of the petition of what you gave.
Okay, so would it, I'm not trying to trick you, Ms. Mitchell. Are you?
We will be allowed to ask questions, right?
Yes, yes. So I think that if you're going to be the one to present, I think it would be best if you take the oath and be treated as a witness. Okay. Anyone that will be giving any type of testimony, Mr. Roller, would you give them an oath?
Yes, sir. If you'd raise your right hand. Do you affirm that the testimony you're about to give to this court here today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
It's my, in 2006, and this particular law that we're referencing in our petition is 2005 007.
That Exhibit B, Ms. Mitchell.
Yeah, let me give you Exhibit B. We have never argued and said that the tribal council didn't have the duties of all Lumbee tribal legislation committees and shall be clearly defined by that tribal council. And you will see that in Section 1 of Exhibit B, 1.1, and Section 2, appointments, and Section 3. We realize and do know that the tribal council has this legislative authority to approve appointments. But when you go to Exhibit B, Section 2 and 1, it gives the remainder of that language that is cited. And to the extent possible, appointees, and the word says shall. It don't say maybe, might, or whatever. It says shall be tribal members who are not seated tribal council members. We believe that the respondents did not adhere to the cited language in Section 3 of that same Exhibit B ordinance. And it says, if an affiliated position is filled by appointment, to the extent possible, tribal members who are not seated tribal council members shall be selected. And furthermore, in that particular Exhibit B ordinance definition. Now, we want to use common law, sometimes, but why do we need common law when we already have law in place? And it gives the definition, and it's as plain and simple as it can be. To the extent possible means highest priority is given to non-council members. We argue that you will see in Exhibit F the resolutions that was passed by the tribal council in 2006, 2010, 2016, and 2022. 2006, my information that I searched for, I could only find what has been exhibited. We do realize that the tribal council has the authority and power to remove appointees. And at that time, I couldn't find any information, so I did ask Mr. Matt Roller. Excuse me just a minute, my mom getting dry.
Can I just interrupt you just for a minute, Ms.
Yes.
Mitchell? Are you referring to a new exhibit? Are you still on Exhibit B, or have you moved to a different exhibit?
Oh, I'm sorry, Exhibit F. It has been given to you. Exhibit F. 2006 exhibit. It is a resolution.
You can proceed.
And that particular resolution was at a time that they were going to do a recall on a tribal representative to the North Carolina Indian Commission. And we realized that they do have that authority, legislative authority to do so. I could not find any other information to have one that is signed. And I did reach out to Mr. Matt to try to get this information. And from what I understand, there's not a lot of written information about it, but there was a dispute at that time that this particular resolution came forward whenever there was a matter between the legislative branch and the executive branch. 2010 resolution, and that's in Exhibit F also, you will see that there was an appointment made in 2010, and it referenced the name in this resolution. And I was a council member at the time, and I did have concerns about this appointment being made by a seated council member. I raised that issue among the other members that are present today serving on the tribal council. But the action was taken that this person was seated and he was a council member.
Let me interrupt you just one more time.
2010.
The first exhibit, Exhibit F,
Yes.
the 2006 resolution.
Yes.
Can you just summarize exactly
Something of what was
that
going
is
on?
and why you're introducing that?
Well, it was a resolution, Your Honor, that during that time, there was a matter between the legislative branch and the executive branch of trying to nominate a representative to the North Carolina Indian Commission. There was a dispute. And I don't know all that happened because I don't have all of the knowledge, but I did have some. I understand at that time that the person that was appointed by the executive branch was a tribal member, not a council member. And I do understand that the council itself was trying to appoint 2 council members to that position. So that was the first of my knowledge when the issue of the particular ordinance that is in place, that there was dispute.
So do I understand you correctly that you're using that exhibit to show that in 2006 that the tribal council first seated a non-council member onto a non-council board?
Without signatures and all the information, I do have, that there was a dispute that the executive branch was appointing a tribal member and that the tribal council was appointing 2 seated council members. But I do not have, and so I don't know what happened. So I did present it as the first case of trying to appoint seated council members to affiliated positions.
And so the second document that you've mentioned in 2010,
Yes.
we won't call that particular name.
No, sir.
But is it your contention that that person was a seated council member at that time?
Yes, it was, because I was on the council at the time, and that's when I raised concerns about a seated council member being seated that was serving as a council member. And the record will show how I voted for that particular ordinance resolution, that resolution.
You may proceed, Ms. Mitchell.
You're also noticed too in that particular resolution that the person that was being nominated to be seated didn't recuse himself from voting for himself. 2016, I was not on the council at the time, but there was another seated council member that was brought before the council for a reappointment. And same Exhibit F of May 2021, there was a seated council member that was seated to one of the affiliated positions that was a seated council member, and you can look at the record and see that that council member voted for himself. April 21, 22, there was another seated council member that was seated to a board, and he recused himself, which was a good thing. But we're still arguing the fact that these all were seated council members that were being appointed to these boards and positions. In Exhibit C, this is a law that says the North Carolina Commission on Indian Affairs Districts. If you look at Section 4 of that particular law, it states that there are 3 seats to the NCCIA. And we have the word again, shall. be filled according to the Tribal Ordinance 2005-007. It is another law that is pairing with the first law that we just spoke about, General Ordinance governing duties of committees, appointments, and government-affiliated positions. And in that law, the particular law that I talked about first, it does have the definition of what the definition means. And I would argue, or say to the court too, in our tribal population, we have at least 65,000 tribal enrolled members. About 59,000 of those are age 21 and up. And about 35,000 of those are eligible voters that would and could serve or be able to serve in those appointed positions. We argue in Exhibit A of the Constitution, Your Honor, duty of loyalty. Constitution, Article 11, duty of loyalty. And it states in part, every elected and appointed official empowered herein shall affirm upon taking office that he or she will abide by the Constitution and laws of the Lumbee Tribe of North Carolina and will, to the best of his or her ability, perform his or her duties with undivided loyalty to the Lumbee Tribe of North Carolina. When city council members are seated in these positions, they begin to divide the loyalty. You take an oath with the Lumbee Tribe of North Carolina, and then when you're appointed to these other boards, especially I know with the North Carolina Indian Commissions, you have to be sworn in too. We argue that they did not adhere to the cited language, and it says, shall affirm upon taking office that he or she will abide by the Constitution and laws. And you can see it written in the Constitution that we uphold the laws that the Lumbee lawmakers make. And we feel that they have violated due to the cited language in those laws. The respondents' unconstitutional actions violated the cited language laws in the Constitution, duly adopted tribal laws which precipitated conflict of interest to perform official duties with undivided loyalty pursuant to the Constitution and the said laws. In Exhibit D.
You specify where you're reading from?
Okay. Exhibit D, okay, I'm sorry. I'm going to get to D. Section 1.1. Ethics and performance of duty. The tribal chairperson, the tribal council members, officers, tribal judiciary, which includes administrative and supreme courts and any courts that might be established in the future, appointees or any other entity owned wholly or in part by the Lumbee Tribe of North Carolina that provides a service with the Lumbee tribal government. We are looking at the third whereas, Article 11, Section 2 of the Constitution of the Lumbee Tribe of North Carolina states that the first tribal council elected under the Constitution shall adopt an ordinance prescribing conflicts in the performance of duty by elected and appointed tribal officials, and which ordinance shall be required a tribal official to recuse him or herself from decisions or vote affecting his or pecuniary interest or that of a family member. And if we just stated in the exhibits of the resolutions, we see where seated council members did not recuse themselves when it came time for a seated position on those affiliated positions. They voted for themselves. And we believe that by them seating themselves, they have caused a conflict of interest to exist in our government. Exhibit E. Tribal Council Rules and Regulations, 2011-1215-001 to 11. Standing rules and orders governing the duties of tribal council officers and decorum of council meetings. You look at, it states in part of Section 2, Well,
Let me just interrupt you, Ms.
okay.
Mitchell. It's not your fault. It's not that easy trying to keep up. You're doing an excellent job.
Okay.
Can you just tell us again which document you're reading from at this time?
Okay, Exhibit E,
Exhibit E.
standing rules of order and regulations governing the duties of the tribal council officers and decorum of council meetings.
You can proceed.
The third whereas, in accordance with Article 7, Section 1B of the Constitution of the Lumbee Tribe, the tribal council shall adopt rules and regulations governing the council's procedure and decorum. In Section 1, it says the duties of the tribal council. Section 2, do you have Section 2? Which would be on your next page, Section 2, tribal council meetings.
Like, we are missing that
That
page.
page. Do you, well, it gives the caption. I mean, we can give you a copy, or otherwise it just describes the caption.
Would you read it and
Yes, it
approach
says,
or pass it down to us and just let us
Okay.
take a look at it?
It says Section 2, Tribal Council, and again, it repeats, in accordance with Article 7, Section 1B, the Constitution of the Lumbee Tribe of North Carolina, the Tribal Council shall adopt rules and regulations governing the council's procedures and decorum. Could you pass that? You do have page 4,
Yeah, page 4.
number 12. It says, all meetings of the tribal council shall follow and adhere to the Constitution, tribal ordinances, standing rules of order, latest edition of Robert's Rules of Order, and or the common law. And again, we find in this language, tribal ordinances, and this is what we are here for today, tribal ordinance that has been violated, and we feel that this has been violated too. When appointments are made, you have to have a meeting. Basically all 21 council members. And it states here that they're supposed to follow, and it says shall, it doesn't say may, it doesn't say maybe. Follow and adhere to the Constitution and tribal ordinances. And Your Honor, I think as far as all the exhibits, that's what we have presented. I think that might be the last one. Exhibit E, yes. And we argue that the respondents is in violation of this law also, and the other laws that they have written and put in place for appointments of seated council members to affiliated positions. It's supposed to be tribal members, and out of 35,000 tribal enrolled members, surely you would find people that would be willing to serve, that would be qualified to serve, and would be able to report back to the tribal council.
Is that the extent of your presentation, Ms. Mitchell?
Yes, sir.
The respondents at this time like to question the petitioners.
Are we simply questioning the witness presented, or is it a rebuttal of the exhibits? Or?
I believe that you can direct your questions to Ms. Mitchell, but I believe that she can consult with any other members of her petitioners and they can speak freely.
Regards to Exhibit F as presented, Ms. Mitchell. That ever voted on?
Sir?
In regards to Exhibit F, I would imagine this is number 1, page 1. The recall of tribal representatives to the Commission of Indian Affairs.
Yes.
That matter ever voted on by the tribe with the council?
I just mentioned that I did not have all of the information assigned. I asked for it from Mr. Matt, but they could not find any information to see if it was signed, so I do not know.
This is a matter you stated you were on the board at that time?
The one in 2006? No, I was not. I was on there in 2008.
But to your knowledge, was a recall of these commissioners ever accomplished?
Sir, I do not know.
I have a question for the respondents. Does the respondents dispute?
Excuse me, repeat that. Excuse me. Go ahead.
I was asking a question to the respondents, and feel free, Mr. Locklear, to consult. And if you don't know, you don't know. The respondents or the council dispute the legitimacy or authenticity of that document.
We have no reason to dispute it at this time, no.
You can proceed.
Also referenced Exhibit D, is that correct?
D, yes.
And could you tell us what Exhibit D is?
Exhibit D?
Yes.
That was the ethics and conflict of interest ordinance.
Did you read specifically from that document?
I read section 1, yes, ethics and performance of duty, and I did read the whereas. Let me go back to the third whereas.
You would look at that document and go to section 1, number 1.
Section, yes, sir.
That state that the tribal person, council member, officer, appointee, or employee, or any person or entity that provides contractual services.
Repeat the question, please.
Could you read what it states?
I read what it stated.
Did Mr. Locklear point the court again where you're speaking of?
We're on Exhibit D, Section 1, Ethics and Performance of Duty. Number 1.
You were asking Ms. Mitchell to read that?
Yes, this provides contractual services. She stated that she already read that. My argument would be to this is that the ethics and conflicts of interest is only in examination. It's only in respect to someone who has in a contractual relationship for pecuniary gain, as stated as she read out under the whereas clause.
How many pages is Exhibit D, Ms. Mitchell?
I did one, so I may have copies of the whole.
We're on the first page.
You're on the first page.
Yeah, but I did relate that to the duties of loyalty to the Constitution to Mr. Locklear.
I just want to make sure that I'm following Mr. Locklear. You're saying that Ms. Mitchell referenced something about persons or the council entered into contracts?
No, she read that statement, and my purpose in having her reread it is that they would be affected if there was some pecuniary interest to be gained, because this ethics statement involves contractual services that someone would provide to the tribe or council. It would be outside of the purview of these appointments because there isn't a pecuniary gain, so it wouldn't be applicable.
You're asking Ms. Mitchell to read section 1, subsection 1?
Yes.
Or you just read it and read it for the court.
The tribal chairperson, council member, officer, appointee, employee, or any person or entity that provides contractual services. My question would be, is these appointments the basis of this complaint that was filed? Are they contracts entered into?
No.
Ask a point of clarification on it. On Exhibit D, you're reading from section 1, number 1.
Is it ordinance number 2005-008?
No.
What do you have? Because
CLLO-2010.
right here, 2010.
That's why we're a little confused.
This.
Does it say
Can I see what you have?
titled Ethics and Conflict of Interest Ordinance in quotation at the top?
Got it.
That's not what you're referring to.
It wasn't, but I can refer to this as well.
Can you tell us what you were referring to? I would like to hear at least what the argument you were trying to make with the previous document that you were referring to.
Okay. As to Exhibit D, she read the whereas section, right? Article 11, Section 2 of the Constitution of the Lumbee Tribe of North Carolina. That's where we all are.
Okay, so is that the same thing that you were referencing earlier?
No, I was actually referencing the ethics section of the rule of law. Your ethics statute or ordinance.
You pass down what you were, and let us just take a look at what you were reading before we proceed. I agree with Justice Jacobs. We need a point of clarification.
All right. Can we strike the previous and then just move on to this?
If that's what you'd like to do, yes.
We can strike, move forward on into this document.
It's titled Ethics and Conflict of Interest Ordinance.
Yes.
Okay, you can proceed.
And that is just one page that was proffered? Okay. We move to the whereas section number 3. This is pertaining to tribal officials, in which ordinance shall require a tribal official to recuse himself or herself from any decision or vote affecting his or her pecuniary interest or that of a family member. Position of the respondents that this is outside, it's not germane to the issue because it's no pecuniary interest of any of the council members that's being appointed. Monetary compensation is what this is prescribed to. So it would only be applicable if they were getting paid contractually. That's the purpose of the ethics and conflict of interest ordinance.
Are you asking that, are you forming that in the form of a question for the petitioners, or are you making that argument before the court?
I can, either way.
Okay.
I mean, I would prefer to just rebut the exhibit in this presentation based solely on the wording of the document itself.
So is your argument that this ethics and conflict of interest ordinance is not applicable at the question at hand because the question at hand does not involve an agency entered into a contract?
No contractual services that would prescribe itself to an ethics and conflict of interest because there is no pecuniary interest.
As to that point, petitioners, would you like to respond to that?
Your Honor, the reason we put this as an Exhibit D is because it does refer to the Article 11 of the Constitution. And also, at one law that was violated, this particular law was cited to be used for removal. So I would argue that when a seated council member is put in a position, it has created a conflict of interest.
Could you repeat that, please?
I stated that this Exhibit D, based on the Constitution, Article 11, Section 2, has, by sitting a tribal council member to an affiliated position, has caused a conflict of interest, especially when the Constitution states undivided loyalty. And also, this particular law was used for a previous removal because they stated it was a conflict of interest. There was no monies or anything involved.
Do you agree that this ordinance, as read by Mr. Locklear, applies in situations where there is a pecuniary interest at stake for the tribal council?
Your Honor, the question that we asked, if the respondents are arguing that this law would not apply to a seated council member, we would ask the question, does the seated positions get compensated for sitting on the positions that they hold?
That's a question that you're directing toward the council. Okay. At this point, I would say reserve that question for the council. When the council presents its case, I would probably note that if I were you, so you don't forget. Is it your position that the council as a whole violated either this ordinance or the duty of loyalty article of the Constitution, or simply the lone person who voted that you are arguing violated the duty of loyalty?
I think it's the whole council, sir, because when a law is written, any law that's written that is adopted and has been in place, everybody has to follow it, all the council members. So I believe that whenever a person votes and vote for a seated council member, they have violated a tribal law that's in place.
So would it be your position, Ms. Mitchell, that every law that has been passed where at least one person voted in the affirmative, voting yes for that ordinance, has acted improperly, that taints the entire law? Is that your position?
When one person has voted no or yes, are you saying yes or no?
Yes. I'm saying that I suppose there's two possibilities, right? You have an ordinance that's passed and it comes down to a single vote. And if that person does not cast their vote, then the ordinance fails, right? The alternative is that person's vote, even if it's yes, and even if they violate their duty of loyalty, if they would have recused themselves, the vote would have passed anyway. Are you saying that in those instances, even those laws should be deemed unenforceable? Yes, absolutely. Any comments or questions by the other justices? Any at this time? Feel free to jump in. And I don't want to suggest to you, Ms. Mitchell, that there's a right or wrong answer to that. At this point, we're still fleshing this out.
I think whenever a resolution or ordinance, a resolution is passed and the law states that it was violated,
yes,
and it passed by the majority or the 2/3 or whatever, it's been violated.
Does the respondents wish to proceed with their question and other petitioners?
Ask a question.
Do you have any other questions for the petitioners, Mr. Lockley?
Exhibit A that was presented, and we're going to reference again section 11. Once again, as to the Constitution, Article 11, duty of loyalty, Ms. Mitchell, could you read Article 11, subsection 2?
The first tribal council elected under the Constitution shall adopt an ordinance prescribing conflicts of interest in the performance of duties by elected and appointed tribal officials, which ordinance shall require a tribal council to recuse him or herself from any decision or vote affecting his or her pecuniary interest or family member.
You read this to mean that The only time one must recuse themselves is if it affects their pecuniary interest.
I believe that they should recuse themselves whenever it's a decision that is affecting his or her pecuniary interest or family member. And as I stated in the resolutions, 2 of those resolutions were they appointed council members, they voted for themselves.
Mr. Locklear, I would just say that if there's something that you want read, you can read it. I know generally our practice in the court of North Carolina that we're not allowed to argue, make argument from making questions, but feel free to read it if you'd like. Can I ask you a question, Respondent Locklear?
Yes.
Would it be the respondent's position that the burden of proof lies with the petitioners whether or not these persons had a pecuniary interest?
Yes. The burden of proof would lie on the petitioners. They reference that particular subsection of the Constitution. It's particularly delineated for pecuniary interest, and there hasn't been any presentation that there was a financial or monetary gain by assuming those positions or voting for fellow council members to take these positions.
That'd be my next question. How would the council define a pecuniary interest?
A monetary gain or compensation.
You disagree with that, Ms. Mitchell?
Your Honor, it's, and I have to say it this way. This particular ordinance, the ethics ordinance, was used to remove 2 members, and they were not getting any pay.
By this
appointment.
By this ordinance, are you referring to, which ordinance are you referring to? The ethics ordinance or
the ethics ordinance,
Okay.
in which, the Constitution is speaking here about a conflict of interest, which is the ethics ordinance that is in place.
When you say that this ordinance was used to recall members, removed members, is that something that you presented, or are you speaking collaterally outside on something else?
Well, I'm speaking of a fact, but it was not entered into court, so.
Okay.
But I'm saying that this particular ordinance the ethics ordinance was used for removal of 2 appointees, and there was no pecuniary interest involved. No monies, if that's the only thing that we're talking about, monies.
Justice, if I may.
Certainly.
If I'm not mistaken, Exhibit F, the first document in that 1 through 5, that is dated November 16, 2006. Yeah, Exhibit F. That document is a removal of a tribal council person from a commission. Is that correct?
The first one in F.
That document talks about the removal.
Yes, Your Honor, I really don't know what the turnout of that was, because I didn't enter a resolution that was done in 2006, but my understanding at some point in time in November, this a resolution came about, and I have no information on whether it was enacted, whether it was followed by, or what, because I asked for the information through our liaison, Mr. Matt, and was not able to get any information. But more than that, this was also used to say that we know that the tribal council, the legislative body, has the authority to remove or recall. They have the authority to appoint. I don't know if they have the authority to nominate, but they have the authority to appoint, and they have the authority to recall. So for 2006. I'm not sure where the
My
district
question on
enacted.
that document, though, this is the only document in front of the court that speaks to the removal of a council member, correct? Does it reference ordinance that you are saying was referenced in documents that are not in front of the court? So you're saying
No,
it does
this
not?
is this particular would reference the appointment ordinance, the 2005-007.
Your previous statements, Ms. Mitchell, as it related to the council removing two persons from a board,
Yes.
that's different than
That's
Exhibit
different,
F.
yes.
You're speaking about something that's not before the
Something entirely
court.
different,
Okay.
yes. But I'm stating too that the ethics ordinance was used with those two removals without pecuniary monies or whatever involved.
Mr. Justice, can we have Ms. Mitchell point us to where this removal occurred, or that's that's not here?
So to my question, she's answered, Ms. Mitchell has answered that what she's referring to is an external event that's outside this court's scope today. I have a question for you, Ms. Mitchell. Mr. Locklear has stated that he believes that it's the petitioner's burden to prove that there was a pecuniary interest at stake, particularly with respect to these violations that you allege occurred. You indicated that you were on the council at the time in 2010, correct?
2010.
When, I believe it was at Exhibit F,
2010.
the second exhibit.
Yes.
At that time, to your recollection, was there a pecuniary interest attached to that appointment of that individual?
I did not see any. I don't know what the requirements are on the North Carolina Indian Commission. I do have pulled some documents from online of the North Carolina Indian Commission of Indian Affairs, and there may be some compensation, but I have no idea what that compensation is.
The specific reason why I'm asking is that you pointed out that your vote was no.
Yes, sir.
In that particular
yes, sir.
Ordinance. Was the basis of your no not a pecuniary interest? Was it?
It was based on the fact that the tribal law was being violated.
As you saw it?
As I saw it. As what was written in law.
Any other questions, Mr. Locklear?
Stated that you were aware it was a violation of tribal law at that time in 2010?
Yes, sir.
Did you take at that time?
At that time, I did talk with other tribal council members and showed them the law that was in place.
Initiate an action with the court at that time?
I did not, and because of that, I was probably about the second person. And we've already had case law, which happened, I think, in 2017, where the court dismissed a case when a person filed a case and it wasn't on behalf of the tribal council. So would the court have heard it? I don't know. I did not file one at that time. But that was not the only time, sir, that it has been mentioned to the council about the violation of this particular law, the governing appointment. It was done in 2006 when there was a dispute was going on. Where's my other notes on there? It was brought up in 2022. I made a notification of it to the council in 2010. And I think it was April of 2022 when there was a tribal member came before the tribal council questioning these appointments of city council members. And I addressed it also in 2022.
Do you have any documentation presented?
I do have it, but I didn't present it to court.
Let me ask you this, Ms. Mitchell, and this is probably something that should have been asked Very early. You're not asking this court to go back and decide that the council has acted improperly in 2010, are you?
No, sir. I'm asking the court to look in the controversy that the tribal law, by the actions of the tribal council, has done in seating council members, and the definition that is therein.
Can you identify for this court what particular act that you believe that the tribal council has did that's in violation of the ordinance? And here's the reason why I'm asking you that, Ms. Mitchell. I do not believe that it's the objective or the purpose of this court to offer what amounts to an advisory opinion.
Right.
I don't believe that this court is pleased to tell either party what this court believes that a party should do, or what the court would do in the event that the party does something. So I do think that there is a burden on you, Ms. Mitchell, to point out to the court an actual violation that you believe is relevant and ripe for this court to decide whether or not a violation has taken place. And I would say that because I don't think that this court, and I don't want to speak for all the justices, but I don't believe that this court has a whole lot of interest in going back 13 years and deciding that that was a violation. If there's something that's recent, that's still in effect, would you point us to that?
Okay. Your Honor, go to Exhibit B.
B?
B.
B.
B. Section 2 and 1. And I'll read it again. The tribal council shall approve all appointments and appointees to organizations, boards, and entities, and to the extent possible, appointees shall be tribal members who are not seated tribal council members. If you will go to Section 3, number 3. If an affiliated position is filled by appointment, to the extent possible, tribal members who are not seated tribal council members shall be elected. If you go to the definition of the same Exhibit B, definition of what to the extent possible means, highest priority is given to non-council members, and that is our argument.
And my question to you is it your position that that is currently being violated?
Yes, it is.
Or it has previously been violated?
Both.
Can you cite for the court what the current violation is?
If you go to Exhibit F, uh, 2021 and 2022. And if you want to go back, there's 2016, but those are the recent current.
You're saying that the appointments in those two cases, in those two appointments, are actively in violation?
I believe so. When we filed a petition, we filed a petition.
Would it be your position that
Your Honor, there is another name that should be added, and that's because we didn't have a resolution, couldn't find a resolution, had not went before the council. But we do know that there has been another appointment to the North Carolina Indian Commission Affairs with no resolution or anything before the council. So we do have 3.
as it relates to the appointee in the 2022, it appears looking at the roll call voting result, it appears that that appointee recused.
Yes, he did, and I mentioned that earlier when I was
Okay.
speaking, yes.
In the 2021, it appears that that appointee did not recuse. Can you offer any evidence or cite any pecuniary interest that that individual may have gained from that appointment?
I do not have compensation of what these boards, these affiliated positions offer or pay. I do not
Okay.
have that information.
Do you have any other questions at this time, Mr. Lockley?
Is the judiciary allowing her to introduce this third person that she just referenced?
I think we'll reserve that at this time. I think we need to get past these first two first. The question that I have for you, Ms. Mitchell, do you believe that if there's ever a time, Mr. Locklear in his opening opening remarks, made the statement that this is not an absolute rule. And I concluded from that, Mr. Locklear, that what you meant was that this is not a shall always appoint a non-council member. Am I mischaracterizing what you were arguing?
The ordinance doesn't present a bar to council members being placed on boards and commissions.
Would it then be your argument, Ms. Mitchell, that the council can't appoint a tribal council member without violating a duty of loyalty?
Based on the duty of loyalty, your procedures and things that you're supposed to do, you're supposed to follow it, even by the Constitution and by the tribal laws that are in place.
You would agree, though, that on its face, that ordinance, which specifies who the council will appoint to those non-council positions, you would agree that it does allow for the possibility for tribal council members to serve on those boards?
I do not, because of the definition that it states in the law, what to the extent possible means. Had this been the desire of the council to appoint these people to positions that are seated council members, then they needed to amend the law.
So it would be your interpretation to the extent possible as to mean always?
I do believe what the law says, how it's written.
Do you have anything that would support that interpretation of to the extent possible?
Just based on the law, sir, that's in place. It's written in front of us.
I imagine that the respondents, the council, would disagree with that opinion, that interpretation.
Yes, Your Honor.
Do any of the other justices want to weigh in on that? What they believe to the extent possible means in relation to Ms. Mitchell's interpretation of it?
Chief Justice,
I'm
please.
sorry. Chief Justice, I have a question. So I'm trying to get some clarification. So how many seats does the council appoint to different areas? Just a rough number. I know you might not know exactly. I see we have 4 here and dating back to 2010. So on an annual basis, how many seats does their council typically appoint?
I think there's term limits on those seats. They come like the North Carolina Indian Commission is every 3 years. There are 3 seats that are given to the tribal council from the North Carolina Indian Commission through a letter to the vacant positions are there. So it's a 3-year term. We do know that we have 5 Lumbees that are on the North Carolina Indian Commission. One of them is a seated council member. 2 of them are seated council members. The United Tribe Board I don't know if their term is 2 years or 3 years, but we hold a seat. Lumbee people hold a seat on that. And on the North Carolina Indian Housing Authority, that's a difficult one to try to really give you a clear answer, but there is some nominations, and I do think that comes from the council by the commissioner. I'm not sure. Mr. Burnett could tell you a little bit more about it because he sits on that seat. But those two appointments are appointments to the North Carolina Indian Housing Authority is done, I'll say, I think, by the governor after the names are sent in from the council or from the commission.
Ms. Mitchell, do you believe that there would be a distinction between the wording of to the extent possible and to the greatest extent possible?
There has been some people who will cite it as to the greatest extent possible, but I see it as what it says in the law. It says to the extent possible means, and I have no other definition that I would pull in there to twist it or say anything else
Yes, ma'am.
except the highest.
Yes, ma'am. I respect your interpretation, and I believe this court is open to considering it. This is somewhat in jest and colorful, but if my wife were to tell me, Mark, to the extent possible, I want dinner cooked when I get home, is that the equivalent of have dinner cooked when I get home, in your opinion?
Well, she may give you a different answer, but I mean, and Judge, all I can say is my belief. The definition, when you do a definition, you follow the definition. When it says to the extent possible, it doesn't say the greatest. It
Yes.
says to the extent possible. Means, that's the definition of mean. Why would you pull in a common law or federal common
Yes.
law to make it mean something else when the law itself tells you what it means?
Well, and in fairness to you, you are citing the definition that's within the ordinance itself,
Within the
which
law.
says the highest priority.
That's what it says.
Chief Justice, if I may.
Yes, absolutely.
Ms. Mitchell, who would get a lower priority than someone getting the highest priority?
Would get the lowest or the highest priority would be the tribal members. And I would even like to ask a question to the respondents.
And before you do that, Ms. Mitchell, again, reading the definition, it says highest priority is given to non-council members.
That means nobody that's sitting on the council.
They get the highest priority. Who gets a priority under them?
Well, I would, I don't know how you would differ that because my interpretation of it is it's not seated council members, not elected by the membership in their districts, their constituents that put them there.
I believe in answering your question, Justice Jacobs, I think, and Ms. Mitchell, correct me if I'm wrong, I think you're saying that there is no lower priority. There is only a highest priority, in your opinion.
Tribal members.
Would you not agree that there are the potential or possible circumstances that make, to the extent possible, untenable?
That are in good standing, more than 35,000.
Why not then pass an ordinance that would say the tribal council shall not appoint tribal council members to these positions?
I think it says that, maybe not in that definition, but let's go back to it and look at it. I think it says shall.
Well, it does say shall to the extent possible.
It says to the extent possible means highest priority shall be to tribal members.
And so my
who are not
question is,
seated tribal council.
my question is That's your interpretation.
That's
That's
what
your
I read
interpretation. That's
from
what
the
you
law.
believe,
That's
is
what I
that
believe.
shall to the extent possible means always.
Shall.
And my question to you is if that's the intention of the tribal council, why not just say always? Why would, in that event, you wouldn't need to provide a definition, would you?
The definition was given in 2005 of what it means. If the tribal council desires to sit themselves on these boards, then they need to amend the law.
If, and again, and other petitioners, feel free to speak up if you'd like. I don't want this to be a back and forth. But if there's tryouts being held for a softball team, and it says that highest priority shall be given to fourth graders, would you say that that would exclude all of the grades?
Well, it depends on what your rule would be. What your rule is in place.
Well, the rule would be to the extent possible, fourth graders shall receive spots.
It's what your rule and law would say.
I don't want to labor this point. I mean, I think you've made your interpretation clear. Any other questions, Mr. Locklear? Okay, Ms. Beck, I'm sorry.
Hi, good afternoon, judges. I would like to offer, since your scenario included trying out for the softball team, that if it said that I'd give highest priority to fourth graders, I would try my best to pick fourth graders out of the 15 fourth graders that try out.
Yes.
And I would want to know who those fourth graders were that I didn't choose that could have fit the definition of a softball team. And adding to that, we could go on and on about this, but why don't we poll the tribal council members that are here and ask them how many tribal members that are not seated tribal council members that they asked to serve in these appointed positions.
Would the respondents like to respond to that query?
The last suggestion
Yes,
made?
yes.
That we query the council members?
Not specifically, but if you would like to do that, we wouldn't oppose you doing that. Let me ask this to Ms. Mitchell, Ms. Beck, and you contemplate that. Do you have any evidence to offer this court what practice or methods the tribal council employed in making these appointments?
Your Honor, we haven't seen any policies or procedures in place as how they begin to vet or ask or what they do, and that was one of the questions we did want to ask them.
I suppose that if your interpretation of this law is that it's an absolute, that it's a shall always appoint non-council members, that's irrelevant for your consideration.
What, as far as having policies and procedures in place on how you do it?
Yes.
That's the relief we're asking for if the court rules in our favor. That there be policies and procedures put in place, because currently there is none. It just everybody plays everything off the cuff.
Is it your position that in the past, since 2021, is it your position that no non-council members have been appointed to these non-council positions?
There have been some non-council members that have been appointed. Like I said, on the North Carolina Indian Commission, there's 3 seats.
Yes.
And then there's some appointments by governor or pro tem, president pro tem, and the General Assembly.
If the tribal council passed a ordinance stating that tribal council members can be considered for these seats on non-council boards,
Would you be opposed to that?
I wouldn't oppose it.
So your problem is just with the language and the application or adherence to this particular ordinance?
It's my understanding, not a problem. I just believe that the law, when it's written, what definition means, you don't twist it to anything else, and that's just my belief.
Any follow-up, Mr. Locklear?
At any time, has the petitioner approached the council and had this discussion in a meeting or presented or asked that some procedure be put in place?
You want to answer it?
That question is directed to you, Ms.
I think in April of 2022, there was a tribal member that approached the council, but there was never a response from the tribal council. And I think I was before them at one time too, and did express this, but there was never no response back to me. So one was in April and one was in November
November of
2022.
Okay. Is the person who presented in April on the panel with you tonight?
No, she's not.
And how long thereafter that meeting did you file this petition? In November?
I think the date is on there, December of 2022. I'm not yeah, it was December.
You stated earlier that there were council members that are currently seated on these positions. Is that correct?
On these positions?
On their
No, not these positions, sir.
So right now, do you know of any council members that are on any positions or boards, committees?
Yes, there are council members on these boards. If you go and look at the Exhibit F, you will see the resolutions, sir, that were voted on by the tribal council, except for one.
Okay, I have Exhibit F, but it comprises several pages. So which page specifically are you referring to?
Are you referring to 21 and 22?
It's the resolutions, the last exhibit, which he asking for tribal council members, or was he asking for city council members?
I think he's asking I think in your opening response to his preliminary motion, you stated that there was a sitting council member currently who is sitting on the outside board. And so I think that his question at this time
On the
is,
affiliated board, yeah, okay. Tribal council member, okay.
Earlier in her reply to you, she stated that there were, I think she even stated 3 council members that are currently sitting on boards. And I'm inquiring as to who those members of the council are.
You want me to tell you? I mean, you want me to call names? If you do, I can.
Sure.
We're all grown.
Okay.
Yeah.
All right. Mr. Burnett sits on the North Carolina Indian Commission. Mr. Corbin Eden sits on the United Tribes Board. And Mr. Gerald Gooseby sits on the North Carolina Indian Commission. And they were seated when the petition was filed.
Are they members of the council?
Were they members of the council?
Are they members of the council?
Not now.
Okay.
so to Mr. Locklear's preliminary motion, he made a motion that made this matter moot. You would disagree?
I would disagree because when the petition was filed.
Let's take a break. Let's take about a 10-minute break. Give us a chance to stretch our legs and use the facilities if we need to. I think that'll give the parties a chance to convene. All rise. Court is at ease. Ms. Mitchell, are there any remarks that you would like to make at this time?
We do have an opportunity to ask questions ourselves to the respondents.
Well, is there anything that you would like to say before we get to that?
We do have a closing statement. You want us to do that now? I mean, I don't have anything except if you let me.
Respondents, is there anything you'd like to say at this time?
Do this, but can you remind me of what we were? There was a question that was asked, and then we went to break. What were we?
I think Ms. Beck had given an illustration about policies and procedures and what the protocol ought to be by the council in making these appointments. And I have to say, Ms. Mitchell, the court has a problem with your opinion of to the extent possible. And it's problematic because it creates a difficulty for the court to put together a reasoning in this matter that would even make it possible for the council to respond. Ms. Beck's question was what policies and procedures ought to be in place to make an appointment to someone to the extent possible of a non-council member. Well, if your opinion or your definition of that is that always excludes tribal council members, that question's moot. It's not even a relevant question, because it means that the tribal council will just always appoint non-council members. And the problem that this court has is that we disagree. We believe that ordinance was written that way specifically so that the council could reserve the right to, at times, appoint tribal council members to non-council positions. That's not the court saying that we believe that that's right. That's not the court saying that we believe that that's efficient or best serves the Lumbee people. That's this court saying that we believe that that was written particularly for that reason, so that there would be times like this where a court would have to come in and make a determine whether or not they've acted to the extent possible. Now, if it were the case that to the extent possible meant that this council will always appoint non-council members to this position, to these positions, it would have been a very easy decision for us tonight. We would have just sat here and we would have said, Ms. Mitchell, or can you point to us persons who have been appointed who were not non-council members? And you would have said, yes, I can name 3. And we would have looked at the respondents and we would have said, do you dispute this? And they would have said no. And we would have said, case closed. But that's not our opinion. Our opinion is that the council does reserve the right to appoint tribal council members to these positions to the extent possible. I think the greater question for this court would be, does this court have the constitutional authority to impose its belief as to what the extent possible means onto the tribal council? And I think that would get us to a separation of powers issue. In other words, suppose that the tribal council believes that to the extent possible means A, B, and C. And the Supreme Court believes that to the extent possible means D, E, and F. I can't say with certainty, Ms. Mitchell, that this court has the authority to impose its belief and its opinion from a judicial standpoint onto our legislature in making that decision. But because you don't even believe that matters, have to get to that point. And I believe that it's the will of this court to decide that you have not met your burden and that the tribal council has not violated its ordinance by appointing tribal council members to non-council boards. Court is adjourned.
All rise.
Always of no effect.
I'd like to thank everyone. I'd like to thank both parties. I know that it's when you receive an opinion this abrupt, it may feel like there's a loser. It may feel like there's a winner. The only persons that win, and this is me speaking off the cuff, this is me speaking as a servant of this tribal government. The only persons that win is our tribal members. Servants, we're not in it to win. Sometimes we lose. And if we lose for the benefit of our tribal members, then we don't lose. And I have to say, Ms. Mitchell, you have done a stellar job. There's not too many attorneys that could have come into a court of law and made presentation the way that you did. And so I commend you for that. I think that this isn't your first rodeo. And this court, when it got this petition and saw the petitioners and the names, not just you, but all of you, we received this with the highest amount of respect for you. And so we don't want you leaving from here feeling like, well, this court just does not want to hear what I have to say. That's not the case. This court values your voice and what you have to say. Counsel, I'm ecstatic that this is the first hearing that we've had to have in a year. That means that apparently a lot of folks find what you're doing is, for the most part, constitutional. With all that said, everyone's dismissed, and an official ruling will be given to both parties in time to come. Thank you. Everyone have a good night.